Well, good morning, everyone. I'd like to welcome you to this morning's webinar. This is George Spees, formerly with the Office of Open Records, and back again to do this morning's webinar on basics of the right to know law. Hope you all have been doing well. A couple preliminaries that I think would be helpful before we actually get started. First is that the PowerPoint that I'm using for this webinar is available on the Office of Open Records website. Go to the training page and you'll see a link that takes you to a lot of resources, including all of the PowerPoints that we use for these sessions. The session is also being recorded. That recording is available. I believe you would send in a flash drive with a self-addressed stamped envelope and a note indicating what you're looking for, and someone will make a copy and turn that around fairly quick to get it back to you. There is also a copy of a previous session of this particular topic posted on the website, which you can refer to, and you might find that helpful as well. Now, during this session, the way it works is I'll be running through the PowerPoint, discussing the slides. If you have a question, you can type it in the chat feature, and I'll do my best to answer it as we're going through the session. First, let's stay on topic. We're talking about the right to know law, so make sure your questions are focused on that area. Also, do your best to keep the questions as brief as possible for a couple of reasons. Mainly, it can just be awkward for me to sit here and have to read a couple paragraphs that people type in while everyone else is waiting patiently. If you do have something that is, specific to your organization or your situation that is unusually unique, we'll do one of two things. We'll either come back to it at the end of the presentation, and I'll do my best to get you steered in the right direction there, or we might direct you to call the office and have someone talk to you directly where, we can go back and forth and again, try and sort out exactly what it is you're dealing with and what the best solution might be for addressing that issue. Okay, so all that being said, let's go ahead and dive into the session and learn all we can about the right to know law within the next hour or so. Okay, why is it important? Well, obviously transparency is a popular buzzword used nowadays, but it is important. There is this growing expectation among the public that government be transparent with its citizenry, that it let the people know not only what it is doing, but why it is doing that. And the right to know law is a valuable tool available to the public for gaining access to records that reflect that. But I like to start these sessions with a very fundamental statement, and it has to do with what the right to know law entails. And it's the purpose of the law. The purpose of the right to know law is to give the public access to public records. And I put this out there for a number of reasons. First is that, there's a lot of misunderstanding about what the right to know law is. People see that term right to know, and they somehow define it as a sort of Google for state and local government. And obviously that's not the case. You'll see right to know requests where a series of questions are written out. I want to know this, I want to know that. Well, that's not how the right to know law works. Rather, it is the appropriate process is that a right to know request is completed, submitted, and the person is requesting access to a public record. The other reason I think it's important, and this might be more so, is that if you, as say you're an agency open records officer, receive a right to know request, and it may not be abundantly clear to you on how to proceed. There's always a backstory. Coming back to this fundamental statement, giving access to a public record oftentimes can prove helpful. And, I recommend keeping this in mind because let's say you've encountered a situation where you may not be sure what the person is seeking. come back to this statement, and a lot of times it can steer you in the right direction. It can help you solve a problem, or at least, like I said, get you headed in the right direction so that the person ultimately gets the information that they're looking for. Now, with the right to know law, which became effective in 2009, there is this presumption, and it is that every record of an agency is presumed to be public. That is your starting point. You receive a request, every record we have is presumed to be accessible to the public, unless, and this is another fundamental tenet of the right to know law, you can prove legally and factually that it is not a public record, that it should not be released into the public domain. The agency bears that burden. I, as a citizen, if I submit a right to know request, I have no burden because the presumption is that it is a public record. But the agency, conversely, let's just say that, you know, for whatever reason, you feel uncomfortable with releasing this particular record. Okay, well, maybe in fact it isn't a public record, but you can't just say it's none of your business or I'm not comfortable releasing this. You have to make a valid legal argument as to why the record should not be released into the public domain. Now, that may sound very daunting at face value, and to some degree it is, but you would be surprised, and hopefully after this session you won't be surprised, at the number of tools that are available to you to withhold a record if you have a valid business case for not releasing it. And that's kind of what we're going to talk about here for the majority of the session. But before we get into that, I want to emphasize that the right to know law is not a confidentiality law. Okay, what does that mean? Well, for starters, there's nothing in the right to know law that prevents an agency from just giving out public records. Okay, I can walk into your office and let's say it's budget season and you've got a stack of budgets sitting on the counter. And I say, you know, I'd like a copy of the budget. You can simply give me a copy of the budget. You don't need to require me to fill out a right to know request form and submit it. Now, you can if you want to. In some agencies, you know, for whatever reason, they have that policy that before we give out any public records, you have to fill out a right to know request form. But there's nothing in the right to know law that mandates that you do that. You can simply give out public records. Even more so, let's say I do have a right to know request and I'm asking for a copy of the budget. You can say, George, you know what? It would save me a lot of paperwork and it would save you a lot of time if you just tear up that right to know request and I'll hand you a copy of the budget. Okay, absolutely nothing wrong with doing that. And why wouldn't I agree to that? I'm getting what I'm asking for, and I'm probably getting it a lot faster than I would otherwise. Now, if I were to say, no, I want to follow the right to know process, well, then you have to do it. Okay, that part is in the law, and you must follow the provisions of the right to know law in responding to my request, even though it may be very easy to simply hand me a copy of the record. To carry this a little further, one of the things we recommend as a best practice is that if you have a website, use your website as a business tool. Take a look at your right to know requests. Identify trends. What are people asking for? Budgets, contracts, salary information, purchasing documents, etc., etc. And then put them on your website. Next time you receive a right to know request, your response can be, that's on our website. Here's the URL. Thank you very much. The right to know law considers that to be a valid response to a request. But more commonly, what you'll notice is that hits on your website will start going up and right to know requests will start going down. And that's a good thing because that will save you a lot of work in the long run. It reflects what people's expectations are nowadays. They would much rather sit in the comfort of their family room, on their home computer, surf your website for the records that they're interested in, as opposed to having to take, an afternoon off from work, come down to Borough Hall, come down to the township building, come down to the school district, submit a right to know request, and potentially wait 35 days until they get a response, okay? Use your website as a business platform. Put commonly requested documents and then some on your website, and you'll find that you're much more responsive to the needs of the citizens, and it makes just good public policy. Okay, so you're subject to the right to know law. What do you have to do? Well, first and probably most importantly is that you appoint an agency open records officer, or what we call an ARO. The ARO is the person legally responsible for receiving requests, processing those requests, and responding to the requests. Now, there's nothing in the law other than this person needs to be either a public employee or a public official. They can be at any level in the organization. It can be the clerk that you meet when you walk in the front door, or it could be the mayor, it could be the school board superintendent, it could be the chief of police. Anyone in the organization can serve as an agency open records officer. This person does not have to be sworn in. They don't have to be voted on by the board. We consider it just as a normal work assignment. Let me make a note here. Okay. Also, there's no limit on the number of agency open records officers an organization can have. It's not unusual for one borough to have one person covering all aspects of the organization. You can go 3 miles down the road to the next borough, and they may have one ARO covering the administrative side of the operation and a second ARO covering the law enforcement, the police department side, okay? It's okay, as long as it's clear to the public, who do I give this right to know request to? Okay, just as an aside, last count, the city of Philadelphia has 40 right to know officers, or 40 open records officers. I use those terms interchangeably. There's no difference. Okay, but again, as long as it's clear to the public, who do I give this form to? You'll be okay. You can come up with your own local rules, regulations, and policies to administer your right to know program, as long as it's not in conflict with the right to know law or any rules or policies that the Office of Open Records has promulgated. Okay. I'll give you a quick example here. The right to know law says that an agency may accept anonymous requests. Okay, well, there's another law in Pennsylvania called the Statutory Construction Act, which helps define what words actually mean. Interestingly, that word may also means may not. So under the right to know law, an agency has the discretion to pass a policy saying we will only accept right to know requests where the person is identifying themselves. Okay, so that's how that would work. And you'll find that there's a fair degree of flexibility and discretion in the right to know law in allowing agencies to, we'll say, custom tailor their own open records policies and programs. You can come up with your own form, and many agencies do. They like to have their seal at the top, perhaps contact information for the ARO, any of those local rules, cost information, and the like. But you must also accept the uniform state form, which you'll find on our website. There's not necessarily anything special about it. It's a good form. Many agencies will link to that. But you can require that a person submit a right to know request on your form, or if they use the state form, then you must accept that as well. Okay, and you can accept a right to know form or a right to know request on a blank sheet of paper or by email. Again, it's up to you how you administer your right to know program to that extent. And then finally, we ask that you provide the Office of Open Records with the contact information and identification information for your ARO. On the website, there is a searchable database of AROs statewide. For the most part, it's populated through a link that we have with the Department of Community and Economic Development's Mundstat system. But another good portion of the database is filled voluntarily by the agencies. And we realize, people move on, they retire, they get promoted, they change organizations. So, one of the takeaways from this morning is check out our website, make sure your records are up to date. If not, there's a form there that you can complete, email it into the office, we'll verify it, then update the database. We're routinely contacted by members of the public where, it might go like, hey, I'm trying to find the arrow for this organization. I looked at their website, I can't find anything. Can you help me out? Or they access it directly. They can do that. And if an appeal is filed, the arrow is the person we reach out to here at the Office of Open Records. So it's important that this data be kept accurate. Let me get a sip of water here. Okay, as far as postings go, you're not required to have a website, but if you do, this information needs to be included on your website as well as a physical posting within your business offices. Use these postings to educate the requester. The more they know, the less problems they will hopefully encounter. So it makes your job that much easier to process these right-to-know requests. So on your postings, you need to have contact information for the arrow. Remember that mantra. Who do I give this request to? Okay, then you need contact information for the applicable appeals office. Now, in 99% of the cases, it's going to be the Office of Open Records, and I would recommend simply including the URL for our website, because that's how most appeals get filed, directly on the website, which goes into our docketing system. Then you need to have a form available. If they don't have a form, you should have one available for them to complete. And then list any of those regulations, policies, and procedures that you've come up with for locally administering your open records program. Let the public know what the playing field looks like before they enter the game, okay? So they know the rules, they're not taken by surprise by anything, and hopefully everything will go as smoothly as possible, okay? The easier you make it for them, the easier you're making it for yourself. And trust me, I can tell you that from experience. What can't you do under the right-to-know law? Well, the first is that you cannot limit the number of requests or number of records that a person seeks within any specific time frame. You can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. If she's inclined to file a dozen requests this week, the law allows her to do that. Now, let me go off script here real quick and readily acknowledge that, for the most part, the right-to-know law is used by bona fide requesters seeking a record that they need for some issue that they're dealing with. But there are those handful of people that have weaponized the right-to-know law and use it as a means to be a pain in the neck. My solution to that is the payment side of the right-to-know law. Most people are willing to pay a nominal fee to obtain a public record. Most people are not willing to pay to be a pain in the neck. So take a look at the payment side of the right-to-know law, and I think you'll find your solution for dealing with those problem requesters. There's also a webinar that we put on the payment side of the right-to-know law where we get into this in a little more detail, and that can help you out. Okay, back on script here. The other thing that you cannot do is require a person to tell you why they are filing a right-to-know request. Okay, you cannot deny a request based on the reason or what you think that reason might be. Okay, so keep that in mind as well when you're dealing with some problem requesters. I like to describe the right-to-know process as an obstacle course, and that's kind of going to guide us through the bulk of the rest of the session here. This obstacle course, it has the start, and then it has 2 hurdles, and the second hurdle has 3 hoops that we have to make it through. All right, And then once you make it over the second hurdle, you're basically saying this is a public record and we're going to release it in response to the request. So let's take a run through this obstacle course. First is that you receive the request. Okay, what do you do when you receive the request? Well, most importantly, you note the date that you receive the request because there are hard deadlines built into this law with no flexibility. And those deadlines can often be determinative as to whether a request and response is valid. And that can go all the way up and have an impact on the appeals that may occur. So you note the date you receive the request, and it can be, simply write the date in the corner or use a date stamp, whatever you want to do. And then you compute the 5 days, the 5 business days that you have to provide an initial response. Now, if you receive the request today, theoretically, tomorrow would be your first business day. And it's your business days, acknowledging that not all agencies are on a Monday through Friday schedule. You can get up into the northern tier of Pennsylvania where some small townships are maybe only open 1 day a week or 2 days a week. If it's 2 days a week, then you would receive the request today. Let's say theoretically it's Monday and Tuesday. So you go to next week, Monday, Tuesday, then you go to the following week, Monday, Tuesday, then you go to the third week, Monday. At the end of Monday would be the end of your initial 5-day initial response period to provide, a response back to the requester. All right. And the law also says maintain a copy of the request. Now, the right to know law says you maintain a copy of all requests and associated materials for 30 days or until all appeals have been exhausted. And keep in mind that if there is an active appeal, this potentially could go all the way up to the Supreme Court of Pennsylvania, and that can take several years. So if you do have an active appeal, hold on to everything, okay, because you don't know how long it's going to take. And then there is another law in Pennsylvania known as the Pennsylvania Municipal Records Act, where if your agency has adopted the Municipal Records Act for how long you're going to retain records, it says hold on to right to know materials for 2 years. Now, I would recommend, and this is purely my opinion, hold on to everything for 2 years. It just seems like a good time frame that, after 2 years, you probably won't need anything. It's not going to represent that much in the way of extra documents that you have to retain. And, I just think for good business practices, 2 years, and you might want to take a look at the Municipal Records Act because it not only addresses right to know materials, but all of the materials that typically an agency would maintain. Okay, questions popped up. For 30 days, is that calendar days or business days? Calendar days. Typically, when you're dealing with the law, business days is specified. And if it's silent on the type of days, you defer to calendar days as a rule of thumb. Okay, usually. Okay, now there's always that exception, but usually it would be calendar days. Good point. Okay, moving on. The right to know law allows you to take an extension if you are unable to provide that initial response within the 5 business days. The law allows you to take a 30 calendar day extension. However, this needs to be, oh, wait a minute, questions popped up. For calculating the 5 days, the day is received day 0, correct? Yes, it is. If it is received, for instance, if it's received today, tomorrow would be your first business day. So Chris, your supposition there is correct. Okay, back to extensions. 30 calendar day extension. However, in order for the extension to be valid, there are some conditions that need to be met. First is that the extension needs to be invoked within the 5 business day window. You can't, like, for instance, wait until day 6, realize, oh my gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, by that time, you've denied the request by default. It's legally known as a deemed denial through your failure to respond within the 5-business day window. Then you need to respond back to the requester in writing that you're taking the extension. And, if the request was received by email, responding by email is acceptable. You need to provide a reason why you're taking the extension. And you can go to section 902 of the law, and it lists, I think it's 6 reasons as to why you would take an extension. We keep these records off-site. It's going to take longer than 5 days to go through them. We want our solicitor to review them, to review the response, to make sure we're not giving out anything we're not supposed to, and other reasons that you could potentially use, okay? Then you provide the date when the requester can expect to actually get the final response, and that's usually the 30th day of the extension. And then an estimate of any costs they can expect to incur. And, it is just an estimate. It's not a hard quote. So you've got your 5 business days, and then you've got the 30 calendar days that get tacked on to the 5 business days. So that's how you kind of arrive at your 35 day. Yeah, Stacy, you were about 2 seconds ahead of me there. Good job. Okay, so now, once we've got everything kind of set as far as receiving the response and what we need to do, we need to answer the question that represents this first hurdle on the obstacle course. Is it a record? Okay, now notice I'm not saying it's a public record. I'm saying, is it a record at all? And I always emphasize and encourage folks that when you're trying to understand a law, make sure you read the definition section, because in the right to know law, which by the way is on our website, you download it for free. It's not necessarily a long law, and for the most part, it's written in English. There is a definition section that provides a definition of what a record is. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, so we've got the key phrase highlighted here. Documents a transaction or activity of an agency. To translate that into English, it means a record basically has to be a document that is about what we do here, is about the work of the borough, the work of the school district, the work of the township, the city, the authority, okay, whatever, okay? Because all day long, we generate communications that may not rise to the definition of a record. Okay, questions popped up. Should weekend days be counted in that 30 days? Yes, okay. 30 calendar days would include weekends, it would include holidays, it would include days where, otherwise you might be closed for a weather emergency. 30 calendar days, okay? You take out your calendar, start at 1, count to 30, there you go, okay? So getting back to, is it a record? Let me just give you a couple examples here. Send an email to a coworker. Hey, I hear a restaurant's opened up downtown. Do you want to meet for lunch tomorrow? Or what do you think of the trades that the Eagles are making and the effect that it'll have on their chances this fall? Or I'm picking up a gallon of milk on the way home tonight. All right, all common communications that you might find if you were reviewing someone's email, but yet have nothing to do with the transaction or activity of the department, of the municipality. Thus, they do not meet the definition of a record, and they would not be considered responsive to a right to know request for my emails. Okay, they wouldn't be included. They'd be off the course. All right, not considered responsive records. You don't have to worry about stuff like that being released in response to a right to know request because they're not considered records. Now, let me throw another example out here. Let's say I'm a township supervisor sitting at home on my home computer in my family room on my personal Gmail account, okay? And I send an email to a colleague on the board saying, hey, my daughter has a softball game tonight. I'm going to be 20 minutes late for the meeting. Okay, now that example, again, nothing to do with, my authority as a township supervisor, not business before the board, no impact on the public that we serve. Okay, not a record. It's off the board, off the course. Now I'm going to change it up a little bit. Same family room, same home computer, same township supervisor, same personal computer, same Gmail account. Everything's the same. But this time I send a message to my colleagues on the board. Hey, I understand tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have some issues with it. Here they are. But why don't you guys tell me what you think? Okay, now there you see the difference. Okay, I am exercising my authority as a supervisor. It is business before the board, and it will have an impact on the public that we serve. Is it documenting a transaction or activity of an agency? Well, yes, it is. But wait, what about the fact that this is my personal computer? It's my personal Gmail account. Maybe I'm doing it on my smartphone. Okay, well, that doesn't matter. You cannot use personal accounts and personal devices to hide the public's business. It is the content of the message that determines whether it's a record, not how it is created, how it is sent, where it might be stored. Okay, so that's an important point to keep in mind. Now, there's absolutely nothing illegal or, unethical about using personal devices. Just be forewarned that those messages could be considered public records based on the content of those messages. Okay, so we've made it over the first hurdle. Now we're coming up on the second hurdle, where we have to answer the question, is it a public record? Notice the difference. Now, in front of this hurdle, there are 3 hoops that we need to address. First, do any exemptions apply? And if so, are we going to invoke them? When I talk about exemptions, these are in the right to know law in section 708B. Again, take a look at the law, go to section 708. An exemption is basically a definition consisting of several paragraphs that define types of records that can be withheld if the agency decides to do so. Okay, now it's discretionary. And if you look at these exemptions, they cover an incredibly broad spectrum of records that a typical municipality would have. For instance, there's one that says, if by giving out this record, it would put someone in physical danger, we can withhold it. Okay, makes perfect sense. There's another one that says, any records relating to employee discipline withheld, because you wouldn't want to give out something that could potentially embarrass an employee. Any record, that would provide information about a minor or personal information like the home address of a police officer, you wouldn't give those out because of safety concerns and the like. Okay, and take a look at them. It's an incredibly broad spectrum of records that you can withhold at your discretion if you believe you have a sound business case for doing so. Okay, so, and keep in mind, this kind of goes back to the fact that the right to know law is not a confidentiality law, because there's nothing in the right to know law that says an agency must withhold a record. Rather, the right to know law says an agency may withhold a record if one of these exemptions apply. So the agency has that discretion as to whether or not they're going to invoke the exemption. If you are, then you would say that basically in denying it, that, this record falls within this exemption and we are choosing to invoke it. All right, and that's kind of, language in a nutshell, how that might work. All right, so you have that exemption now, or you have that hoop. Now, let's say that none of the exemptions apply, or if they do, you're choosing not to invoke it. So you've made it through the first hoop, and we come up on the second hoop, which is an important one, just like the first. Are there any federal or state statutes or a judge's order that make these records non-public? And this is described a little bit greater with section 306. There are other laws out there that define records as confidential. And for the most part, these laws do not give you the same discretion that the right to know law does. The right to know law says these records can be withheld or may be withheld. These other laws usually say they must be withheld. Two quick examples. Police departments deal with a law called CRIA, the Criminal History Records Information Act, where it says that there is a body of records that can only be shared among the law enforcement community and may not be shared with anyone else. It's actually illegal, a violation of the law to do so. Then school districts, they deal with a law called FERPA, the Family Educational Rights and Privacy Act, which make it illegal to share any individual educational records. Okay, so they would risk losing their federal funding if found in violation of FERPA. Those laws trump the right to know law. Okay, so they remove any discretion that the right to know law would otherwise give them. And then we come up on the third hoop, which is the record protected by privilege. Here we're talking about, for the most part, attorney-client privilege. Any sensitive information between a lawyer and their client is usually protected by privilege. And with municipalities, we're talking about the solicitor providing legal guidance and advice to the board, the mayor, senior management. Same way with school boards, authorities, and the like. Those communications, whether they be emails or memos or reports, are protected by attorney-client privilege, and thus, and that's supported by the rules of evidence in Pennsylvania as well as statute. And you can find a further explanation about that in Section 305 of the law, where any of that information is considered confidential based on the application of attorney-client privilege. Okay. Can we get a copy of this presentation? Yes, you can. As I indicated when we started, the PowerPoint is on the website, on the training page, and the recording you can send in a flash drive. Okay, moving on here. Another sip of water. I'm dealing with a very mild cold, and the medicine is making my throat dry, so I apologize. Okay. Let's assume then that we have made it through the obstacle course. Everything's approved, we're at the finish, and we've decided it is a public record. But the person has to pay for it because the right to know law is not free. So let's talk about payment issues very briefly. First, this is an important one because most people don't realize this, and there's a lot of misunderstanding. Listen, the agency is only required to provide the record in its current medium. You'll find this language in Section 701. I've more or less paraphrased it. But to explain this, it's basically hard copy versus electronic. The agency is not required to convert a record from one medium to another. So here's my example, building permits. The borough has a building permit program where, I want to make some additions to my building. I need to receive a building permit. I submit the application and all associated records to the borough, and it's all hard copy. The approval process that the building codes inspector and so forth go through is all a physical process, and the approved permit is a hard copy document. Everything then gets compiled into a file folder stored in a file cabinet. Okay, it's all a paper-driven process. But someone then turns around and submits a right to know request. They submit it by email and they say, I'd like a copy of these building permits and I'd like them emailed to me. I want them electronically. Well, under that scenario, the borough is not obligated to scan in the records because that would be converting them from hard copy to electronic. You see how that works? Okay, you're not obligated to scan in the records. Now you can if you want to. And many agencies go ahead and do that because it's just easier. But you cannot charge for electronic records. Okay, there is no charge for electronic records under the right to know law, only paper copies. And you can go to the website, look up the fee schedule, and it will list, it's basically up to 25 cents a page for single-sided 8.5 by 11 black and white. And then again, take a look at the footnotes on the fee schedule because that will help explain a lot of the details as to how you apply the fee schedule. Okay, then let's talk about inspection real quick. Under the right to know law, a requester has two options. The first and most common is I want copies. The second is that I want to actually see the originals. I want to be able to come into the office and view the records directly. Okay, and when you do that, the agency's in the driver's seat. It's when during normal business hours it's convenient to have someone come in to review these records. Now, let's say during that inspection, and by the way, you can supervise the inspection. You can sit there and watch to make sure that nothing is destroyed, altered, or stolen. If they pull out a cell phone camera and take a picture, they are allowed to do that as long as it's not a copyrighted record. Okay. They can even bring in their own scanner or their own copier as long as it's not disruptive to office operations when they do that. Okay, but basically cell phone pictures are okay. You cannot charge for labor. You cannot charge for the act of redaction, and you cannot charge for any legal fees that you may be charged by in-house counsel or a contracted solicitor. That's simply considered the cost of doing the government's business as it relates to the right to know law. You can only charge for actual costs or what are called pass-through costs. Postage is a good example. Let's say that it's a completely manual process. Someone has requested hard copy records, and the arrangement is such that they want the copies mailed to them. Okay, well, in addition to what you're going to charge for the hard copies, you can take that, put it on your postage meter. Let's say it's $3.15 to mail it all out. You can add the $3.15. Okay, I've kind of alluded to this with educating the public, but no surprises. When you get a request, as long as it's not like really small, I recommend do a quick estimate and then call up or email the requester. Hey, we think this is going to cost you $30. Are you okay with that? They're either going to balk at it and withdraw their request, or they're going to say, yeah, fine, that's reasonable. I kind of figured that's what it would run me. Okay, communication is good. If you have any questions, if it's not clear to you what the person is requesting, there is nothing in the right to know law that prevents you from reaching out to the requester and having a conversation. By the same token, if you're a requester joining us today, there's nothing preventing you from contacting the Arrow and further explaining what it is you're looking for, maybe why you're looking for it, if you want to divulge that, et cetera, okay? Get on the same page. Make this process as painless as possible. Now, as far as payment goes, ideally, you have a mutual exchange. Here's your record, here's your payment, okay? But the law says, and again, I'm paraphrasing, that records are provided upon payment. That means you pay up front, then we provide the records. And when we mention the deadlines, the 5 business days, the 30 calendar days, note that that is the date the response is due. It is not the date the records are provided. Okay, the law says you either grant or deny the request by a specific date. When you actually provide the records would be a reasonable date following that, if that's how you choose to operate. So, conceivably, you receive the right to know request, you provide a response that grants the request within the 5 business days, and with that request, with that response, you would say, as soon as you provide us payment, then we will mail you the records or email or whatever. Okay, I don't know why I said email, because there's no charge for electronic records. But you would mail out the hard copy records once you receive payment, and that payment has, let's say they send in a check, the check is cleared. Okay, you can do that. Okay, the right to know law allows you that flexibility. So when push comes to shove, payment is provided first, and then the records are provided. But you must provide the responses within those defined or prescribed deadlines that you'll find in the right to know law. Now, let's say that you receive the right to know request, you do your quick estimate, and it's like, oh, this is going to exceed $100. You can stop the clock and say, send us a check for this estimated amount that's exceeding $100 before you begin any further processing, like making copies, committing time and man hours, et cetera, et cetera. I like to refer to it as like a security deposit. The right to know law ensures that you don't get stiffed for payment for these really big requests. Rather, you can say, hey, this is going to cost, conceivably $120. Send us a check, which we will hold until we're done processing your request, and then we'll settle up on the exact amount. Okay, so if there is no charge, is the record due by the 5th day? No, that's not what I'm saying, Stacy. If there's no charge, the response is due by the 5th day. And then you would provide the records within a reasonable period of time. Okay, but since there is no charge, obviously you've already done some research and so forth, and hopefully identified the responsive records. So it shouldn't take you long after the response to actually provide the records. Okay, it all works out in the end if you see how the logic works there. All right, hopefully that addresses what you were concerned about. Okay, so the prepayment is only if it exceeds, or if it appears to exceed, $100. Now, there's also another scenario, which we call record discard, which occasionally comes up. It's detailed in section 905. The scenario would be, I was always trained to give the information by the 5th day. You were not trained by me. Okay. Okay, so yeah, getting back to this. The scenario is such that you receive the right to know request, you grant the request, and through conversations with the requester, it's agreed that we will provide you with the copies when you come down to the office and provide us with a check. That's fine with us. That's how we're going to work it out. Okay, everybody's happy with that arrangement. Well, under this provision of the law, you now have 60 calendar days that you have to hold the records. 2 months. And if after 2 months, the person hasn't showed up to get their records, you can discard them. You can throw them in the trash, you can shred them, you can recycle, whatever you do. All right, that's how it works. It's not your fault that the person can't come within a 2-month period to pick up the records that they requested. Now, let's just assume that it costs $30. That's how much they were supposed to pay. And on the 61st day, they come walking in to retrieve their records, and you've already destroyed them. Well, they're out of luck on several different levels. First offhand, they still owe you the $30. Like I said, you did everything you were legally required to do. It's not your fault. And if they still want the records, they're going to have to submit a second right to know request. That is probably going to cost them another $30. And you do not have to process that second request until they've settled the debt for the first request, even though the records were destroyed. And let's take this one step further. Let's say that they don't even want the original records anymore, but they submit a right to know request for a completely different set of records. Well, again, you do not have to process that second right to know request until all debts are settled for the first right to know request. Until their account is no longer in arrears, everything's put on hold. Do we have to let them know that we are discarding the records after 60 days? No, you do not. Although, if you want to send them an email, let's say you have their email address, I think that would be a good idea. Give them one last chance. But, the law says 60 days. Okay, so the point being that if there are any outstanding debts, you no longer have to process any further right to know requests. However, because you are denying processing a further request, you want to make sure all your I's are dotted and your T's are crossed, because it's a denial and it can be appealed. So if you are denying for non-payment and it gets appealed, the appeals officer is going to want to see all of the documentation, the original request, all of the communication that went back and forth. How was the debt calculated? How was it incurred? And if everything is in order, the chances are very good that the appeals officer will agree with your reasoning there and deny the appeal. But if things are sloppy, if they can't understand how the debt was incurred and so forth, they will usually rule in favor by default for the requester. So make sure you're doing everything copacetic there. All right, but the point being, you can deny a subsequent request for non-payment if there is an outstanding debt on a previous request. Okay. Let's go in the other direction. Let's say that rather than approving the request, you've denied it based on it not making it through the obstacle course. You've got to provide a denial letter. And here is the format that we recommend. First, you describe the requested records. Now, you're thinking that seems like a no-brainer, but let's say that the requesters, they're not an attorney, but they play one on TV. And they use a bunch of legalese, and it may not be absolutely clear what it is they're requesting. And through conversations or attempted conversations, you haven't been able to clarify it. So you put it in your own words. We believe you're requesting these records. Okay, and you're framing the issue, which is very useful just in case an appeal gets filed. And then you give the legal and factual grounds for denying it. Why isn't it a public record? And remember, at the beginning, I said the agency bears the burden. So this is where the rubber hits the road. You would be citing, maybe one of those 30 exemptions that we talked about. You define the record, and then you cite the exemption and why the record falls within this exemption. Or maybe it's one of those other laws, or maybe it's attorney-client privilege. Okay, but you use the legal basis for why you're denying the request. Then you put the name and contact information for the arrow. Because remember, this is the person legally responsible for responding to the request. So you need that information on your response back to the requester. The date of the response. This is important because an appeal window suddenly opens up, and it's based on the date of the response. And then you need to detail the procedure for filing an appeal with the applicable appeals office. Like I said earlier, in most cases, it's going to be you have 15 business days to file an appeal with the Pennsylvania Office of Open Records. Here's their website address because they can file the appeal right online. Okay, so that's how you would issue a proper denial letter. Now, like I indicated, the person now has 15 business days to file an appeal with our office, and it's our business days now, and we're a Monday through Friday operation. So, that's how it would be applied. Most of these appeals get filed, like I said, online. Oh, questions popped up. If you provide other contact information for the arrow specifically, and the main telephone number of the office is the specific telephone number of the arrow legally required in the denial letter. No, as long as you provide a reasonable exercise that ultimately, without any headache, results in being able to contact the arrow, that's fine. Okay, so the appeal gets filed on the Office of Open Records website, ideally. And a complete appeal when it's received, it's reviewed. Well, first offhand, when the person files the appeal, they get an electronic confirmation. Then a couple days later, they get confirmation of the appeal and instructions, and it's also sent to the agency that the appeal was filed against. But we review it. We look for a copy of the original request, a copy of the agency response, provided there was one. The person needs to provide a statement why they believe the records are public, and then a statement why they believe the agency's denial is incorrect. If they fail to meet these 4 criteria, we issue what's called the deficiency notice, and we give the person a couple days to correct the deficiency. If they do, the appeal gets docketed. If not, the case gets dismissed because of the deficiency. Okay, but let's say everything is there, the case gets docketed. We send out a package, like I indicated, both to the person filing the appeal and to the agency that the appeal is being filed against. And it's mainly for the benefit of the agency. And it's a notification that an appeal has been filed. Here's what that means. Here's what you need to do, et cetera, et cetera. Now, if you're an agency open records officer and you receive one of these notifications, this is important, folks. Run, do not walk to your solicitor, because everything I've described up to this point has been what I'll call an administrative process. When an appeal gets filed, the Office of Open Records has been defined by the Pennsylvania Supreme Court as an independent quasi-judicial tribunal. That means that we are also a court. And an appeal is a legal action. It's a suit against your municipality. Your solicitor will know how to respond and will figure it out. As an agency open records officer, you are not expected to know how to respond to an appeal. And please don't attempt to do so, because we require certain forms, certain language, certain format, because the courts require it of us. And we would hate for you to lose an appeal based on a procedural error rather than the merits of the case. Okay, so put your solicitor in the loop immediately. Don't waste any time. Okay, that's important. Maybe the most important thing that you'll learn here today. Okay, so you've got all these instructions. Your solicitor becomes the contact person. You may still be the boots on the ground, and we proceed with the appeal. The product of the appeal is what's called a final determination. This is the decision that's rendered by the appeals officer. These are legally binding final orders. They look just like you would see coming out of your county court of common pleas. Same format, same language that's used, everything's almost identical. They're usually issued within 30 days. Occasionally, a 60-day extension is requested. You can find copies of them if you have access to the legal services like Lexis or Westlaw. You can even Google in a final determination based on the docket number. You can also find them on our website in a searchable database. You can search on your municipality. You can search on the legal issue. You can even put in a random text string, and you know, all those final determinations that deal with that issue will come up. Okay. There is an option known as mediation that you may wish to consider. Sometimes you get the impression that the parties haven't really been talking to each other, and mediation does just that. If the person, when they submit the appeal, indicates, yeah, I'm agreeable to mediation, and then the agency, when they get the notice of appeal, there's a form in there that they can read and say, you know, yeah, I'm willing to consider mediation. If both parties are in agreement, we have trained mediators on staff that the case will get assigned to. Sometimes all it takes is a conference call. Get the parties talking to each other, they're able to agree, and the problem goes away, okay? No harm, no foul, no precedent, no nothing like that. And if the parties can't agree during mediation, then the case can get pulled and assigned back to a regular appeals officer, and you proceed. But mediation is usually a useful tool that can save you time, can save you money, something to consider. Take a look at it as an option. Okay, our decisions can be appealed to a higher level court If you're a local agency, it would go to your county court of common pleas. If you're dealing with a state agency, it would go to the Pennsylvania Commonwealth Court directly. You have 30 days to file the appeal, whether you're the agency or the requester. You have to notify us that you're doing so. We are not a party to the appeal, okay? We are the lower level decision maker. The dispute is still between the requester and the agency, but you notify us because we track it. We may submit briefs to the court if we believe it's an important legal matter, or we may, in fact, request to litigate, to actually argue the case before the judge as an interested party. So right on schedule, we're at the end of the presentation, but I want to encourage you before we end to take a look at this website I've been referring to. It is simply the best government website you'll ever encounter. Enough said. It is updated 6 days a week with new decisions that are issued by the office, court cases that are germane to either the right to know law or the Pennsylvania Sunshine Act, government transparency in general. On the site, there are guides for citizens, guides for agencies. We have an agency open records officer guidebook that's 78 pages long, filled with all kinds of forms and templates that you can use for running your program. All of those final determinations we've issued, 30,000 decisions and counting in a searchable database. Also, we have a case law index so that, let's say you're a solicitor and you want to get up to speed on case law with the right to know law. You can refer to our index and it'll give you summaries of these important cases. And then if you're interested in further training, we have a training page with a training calendar and also emails and phone numbers that you can reach out to with your questions, with your concerns. And our turnaround time is very responsive. So feel free to reach out to our office with any issues that you may have. We cannot write requests for you. We cannot respond to requests for you. That's your job. We can't predict how an appeals officer will rule, but we can point you towards similar decisions, how they played out, and how the courts responded to various legal matters as well. Okay, so I'd like to thank you. Your questions were very good today, right on point, and we appreciate your participation. In 2 weeks, we will be doing another webinar, same time, Wednesday morning, 10 o'clock, on basics of the Sunshine Act, which is Pennsylvania's open meetings law. Hope to see you there, but again, thank you for your participation this morning, and we'll be logging off here directly.